brother down. With Shizzy, Wiz, Nut.
An open letter to the court of public opinion on the relentless litigating. To the casual observer, Lips might seem like just another loud character in an endless scroll of online drama. But to anyone who's had the misfortune of being in her legal blast radius, she's a case study on how a person can weaponize the court system not to seek justice, but to wage war poorly, repetitively, and at everyone else's expense. Randy's latest filing just doesn't point this all out. It gift wraps it with a statutory ribbon under Florida's newly sharpened vexatious litigant law to anyone who still believes Lips is some misunderstood crusader for truth. Well, buckle up. This woman who has made suing people her full-time cardio, burning through court dockets the way that the flea burns through packs of smokes, leaving behind nothing but ash, stink, and a pile of dismissed stamps. In the last 5 years alone, she's taken aim at former associates and failed defamation attempts, turned a guardianship dispute into a personal vendetta and lost on appeal, tossed out meritless emotional distress claims that collapse under their own contradictions, and even tried to spin family court losses into some moral victory for the live stream crowd. Not one of these filings has ended up in triumph that she promises her audience. All have ended the same way, with the court saying no and her blaming everyone but herself. This isn't cherry picking, it's a pattern. And under HB 1559, the pattern doesn't matter. It's the entire test. The new law widens the net to include family, small claims actions, extends the loopback period to 7 years, counts frivolous repeat motions on the same case, and directs clerks to flat out reject future filings without court permission or a hefty security bond. Well, in translation, the legislature saw exactly what people like Lips is burning judicial time and taxpayer money, and they wrote a law to shut that shit down. Now, Randy's motion essentially holds up her history and says, here's why the statute was written. And when you see the sequence laid out, the meritless filings, the contradictory testimony, the evidence of destruction, the theatrical victim pivots, it's impossible to argue otherwise. She hadn't just filed bad cases, she's industrialized them. The docket is her diary, opposing counsel her unpaid supporting cast. The courtroom is her stage for an audience that she constantly rattles that claptrap or her cup at. The statute calls this vexatious. Most people just call it exhausting. But now that script is different. The automatic stay provision means the moments the vexatious motions hits, she's stuck. The expanded registry means her name, once the court grants this, will be on the statewide list that every clerk can see. The filing restriction means days of casually dropping a new lawsuit like a Facebook status, they're over. While she'll need permission just to step on stage again, the odds of her getting it without changing her act are about the same as her suddenly preserving evidence. For years, she's treated court orders like decor, something to glance at but never actually follow. She's treated the truth as flexible, deadlines as optional, and the harm to others irrelevant. Randy's filing, paired with the HB 1559, makes clear that the harm is no longer hypothetical. It's immeasurable, documented, and about to have legal consequences she can't stream her way out of. This isn't about silencing criticism. It's about silencing the gavel-clogging noise of someone who mistakes litigation for lifestyle content. Storm into court swinging accusations like a drunk with a bar stool and then crying injustice when the bartender takes the stool away. But instead of just telling you she's contradictory, I have some samples below. Lips, I have never sought to defame anyone. My only intent has been to speak the truth. The court said in a final judgment of defamation action, plaintiff offers no admissible evidence supporting the alleged truth of the statements at issue. The record reflects reliance on rumor, assumption, and unsupported opinion. Lips, I have complied with every procedural requirement in the guardianship appeal. The court, in a due to DCA mandate, appellate repeatedly failed to file required documents within deadlines despite multiple extensions and warnings. Lips, I have suffered severe anxiety and fear for my safety since learning of these statements. The court, in a summary judgment about emotional distress action, plaintiff's own social media posts during the relevant period contradict claims of emotional distress, instead reflecting active and voluntary public engagement regarding the dispute. Lips, I have preserved all relevant evidence in the matter. Plaintiff's deletion of entire YouTube channels, community posts, and associated accounts after the commencement of litigation constitutes willful spoliation of potentially relevant evidence. This is the same person, when faced with discovery demands in the Anti-WTH saga, didn't preserve any of the evidence. She went full scorched earth. Darling, she was deleting YouTube channels, community posts, and group chats like she was clearing browser history before a parole check. Whole threads of coordination with other anti-Hales agitators vanished. Videos calling for pile-ons, gone. Accounts used to seed outrage, gone. And yet, with a straight face, she's demanded that her opponents cough up every single reference to her while pretending her own purge never happened. The irony is thicker than a Florida humidity warning. She wanted the plaintiffs to produce all communications about her, but when shoes on the other foot, delete, followed by public denials that the shoe even existed. Here's a woman who has spent the better part of the last 7 years treating the judicial system like a drive-through, placing orders for restraining orders, defamation claims, guardianship appeals, and miscellaneous revenge lawsuits with the same detachment you would use to order a cheeseburger. Now, when her filings flop, and they always flop, the courtroom warrior costume gets shoved in the closet, and out comes the "Oh, poor me" ensemble. The lighting dims, the voice gets quieter, the script pivots from vague threats to her children that somehow make her into an actual police report. Her harassment claims always boil down to the same thing: people noticing she's about the common denominator in a string of failed lawsuits and public meltdowns. She whispers about being silenced while chattering nonstop on streams. When faced with procedural deadlines, she acts like the court's calendar is just a suggestion, missing service requirements even when given grace periods, and then accusing everyone else of dodging her. The record tells a different story. Orders to show cause addressed squarely to her failure to prosecute, dismissals entered after she simply didn't show up, and motions denied for lack of evidence so glaring you could drive a bus through them. And just make no mistake, this has never been a selfless crusade. From the failed guardianship appeal to the back-to-back defamation defeats, every loss becomes a hook. Help me fighting really means pay me more attention to file the same bullshit in a different wrapper. Her pleadings read like bad improv. Insert an emotion, a dollar figure pulled from the clouds, and a closing paragraph that treats opinion as evidence, all the while accusing others of wasting the court's time. That projection can be seen from space. Now, with the amended motion to declare her a vexatious litigant, the paper trail is finally lined up like an intervention. The guardianship mess she dragged through the appellate court, the personal grudge masses disguised as defamation suits, the repeated attempts to weaponize emotional distress claims against anyone who dared to criticize her, they're all final, all adverse, all well within that 5-year window Florida law sets for saying enough. And unlike her bullshit spin, the statute doesn't care about her tone or her tears or her audience size. It cares about the facts. The docket has her diary. The facts are brutal. She has treated the judicial system as a stage for her personal soap opera, and the docket has her diary and opposing counsel as unpaid extras in her one-woman bitch fest tour. Every motion she files steals resources from cases without actual merit, and every dismissal she earns proves she was never in it for justice. Every pivot to victimhood is an insult to people who actually have something worth defending in court. The amended motion isn't some conspiracy to silence her. It's a logical end to years of performative litigation and self-inflicted wounds. The statute calls it vexatious. The rest of us call it finally holding her accountable. Frankly, Your Honor, the only thing left for her to file at this point is a change of address form to whatever corner of the internet she will still believe is in her own doing. The amended motion to declare her vexatious litigant isn't a political hit job or an attempt to silence her. It's the inevitable consequence of 5 years of back-to-back courtroom failures, failed defamation cases, a tanked guardianship appeal, tossed harassment claims, and an emotional distress suit that imploded under her own keyboard. Florida law sets the bar at 7 years. Final actions in 5 years. She's cleared that without even breaking a stride. The statute calls it vexatious. The court calls it meritless. The docket calls it history, and history calls her done. And the rest of it, we call it long overdue. Signed, that Velcro shoed, short bus riding, window licking R-tard from the Peanut Gallery, a.k.a. Shizzy Wiznut. Or you can call me Papa Nut. I love you guys.
It is about time. Let's break this mother down.